I'd like to take a moment and address everyone who is still giving Phil money. As of last Friday, January 31st, 2020, if you are still giving Phil money, there is concrete, irrefutable proof that you are an idiot. With documentation of his level of debt freely available for anyone to view, one can only come to a single conclusion: when you give Phil money, you are not supporting a man and his hobby. You are supporting a man and his habit of unwise, extravagant spending and his flat unwillingness to plan for his future. You are not keeping him alive. You are not helping the stream. You are encouraging and enabling an addict. Regardless of what Phil spent his money on, the fact that he was able to run up credit card debt on anything into the six-figure range should be all the evidence you need that the money Phil gets only goes to one place: himself. This, for anyone with two firing neurons, should invalidate 10 years' worth of him insisting that the money he gets bolsters his business. That if said money goes away, then he'll need to stop streaming, and that his company is his life. These are all lies. We have suspected this for years. Now we have facts which support it. If you're giving Phil money because you want him to still have nice things like a $400 coffee maker and a new, at the time of acquisition, car, that's fine. I don't understand you, and I think you may be a chud in disguise, but at least you're being honest. But if your rationale for donating to him is still he needs it to survive, or I want to see him keep making content, or he got screwed over with bills, then with these documents out in the world, I'm afraid there's no longer any hope for you. You have been hornswoggled by a fat pasty mendicant, and at this point it is completely willing on your end. You're keeping your own asshole greased up for his personal use. I entreat you, stop. Not because of anything else to do with Phil, but because there's no way of you knowing whether you'll need all the money you've given him tomorrow. Call it a SO or a community service. He does not deserve your help in bailing himself out after years upon years of hitting you up, time and again, and in the background running up debt because he still, after all of the begging, doesn't have what he needs to buy the things he wants. Don't allow him to cry poor at you. Don't allow him to make you think his circumstances are the fault of anyone but him. You have the evidence sitting in front of you. Look at it. Study it. Ask yourself if what you see there adds up with everything Phil has always said. And if you come to your senses at that point, there is only one course of action that makes sense. Stop giving Phil money. 341 Meeting structure and questions. This page describes the structure of the 341 meeting and the questions that our office asks during the meeting. Overview. 341 of the Bankruptcy Code states that trustees shall call a meeting of creditors to be held. The business of the meeting shall include the examination of the debtor under oath. The meeting is held by a member of the trustees' staff. The debtor, joint debtor and the debtor attorney are required to attend the meeting. Creditors may attend if they wish. The purpose of meeting is to review the petition and schedules with the debtor to ensure they are accurate, resolve any issues that may impact confirmation of the plan, and to give creditors an opportunity to question the debtor. Meeting. Prepare computer and escort attendees to room. Select case in the 341 worksheet function. Announce case in the reception area and attorney area. Escort people to room and have everyone sit down. Turn on recorder and state case information. Turn on the recorder. Complete recording label information. Good morning. My name is Hearing Officer. I will be the hearing officer for this meeting of creditors required by Section 341 of the Bankruptcy Code. I am a representative for the trustee in this case. This meeting will be tape recorded as required by bankruptcy rules. I would like everyone to please speak clearly when asking or answering questions. This is the case of debtor names. Case number. Today is date. Ask attendees to state their appearances. Address debtor attorney counsel, please state your appearance. Debtor attorney announces name and client's name. Address debtors, please state your name for the record. Debtor announces name. Address creditor representatives, please state your appearance. Creditor representatives announce name and the creditor they represent. Explain meeting process to debtor. We are here today to make sure the documents you and your attorney have submitted to the bankruptcy court are correct. Also, we will try to make sure your plan to repay your creditors will work. In order to do that, I will ask you some questions. If any creditors are present, creditors will have an opportunity to ask you questions about your case. Swear-in debtor. Before we start with questions, I will ask you to take an oath to tell the truth. Please raise your right hand. Do you swear or affirm the testimony you are about to give is the truth, the whole truth and nothing but the truth? Debtor must answer yes aloud. Thank you. If at any time you want to ask me a question, please feel free to do so. Verify name, social security number, address, prior filings. Debtor's first name, joint debtor's first name. Are you married to each other? Use information from petition and question the debtor. Mr. Ms. Debtor's last name. Have you used any other names during the last 6 years? Is your social security number debtor social security #? Do you live at debtor's address? Have you ever filed bankruptcy before? Skip this question if a joint case. Is your mailing address debtor's mailing address? If there is a joint debtor, use information from petition to ask the following questions. Have you used any other names in the last 6 years? Is your social security number joint debtor social security #? Do you live at debtor's address? Have either of you ever filed bankruptcy before? If this is a repeat filer, ask the following questions. How long have you been on your job? Is this the same employer job you had in the last case? If it is the same job, ask why this case will work when the last one didn't. Pro se debtor. Ask the following questions. Did you receive help with the filing of your petition, schedules and plan? If yes, what is the occupation of this person? Did you pay them for their services and how much? Obtain the name, occupation, phone number and address of the person. Business cases. Ask the following questions regarding the reporting package mailed to the debtor and debtor attorney. Our office mailed you documents regarding the operation of your business. Did you receive them? If yes, ask for the completed forms. If no, give them a copy and explain we must have the completed forms 1 week prior to the confirmation date. Do you have any questions about the forms? Verify schedules, property, debts, income and expenses. Show debtor joint debtor copy of petition and schedules. This is a copy of your petition. Did you see these documents before you signed them? Have you listed all of your property in these documents? Review schedules A and B. Have you listed everyone you owe money to in these documents? Review schedules D, E and F. Did you bring a pay stub with you today? Ask for all of the stubs available. Verify the accuracy of the scheduled income. Have there been any significant changes to your budget? Allow creditors to ask relevant questions. Address creditor representatives. Do you have any questions? Limit the creditor to questions about collateral and insurance issues. Ask about the creditor's claim amount if not on file. Verify accuracy of claim amounts and equity. Update information on 341 worksheet. Address debtor attorney. Are there any unpaid attorney fees? Enter data on system. Verify the following dollar amounts and numbers and inform the parties of the terms of the plan. Monthly plan payment. Months in plan. Estimated percent. Recalculate computer worksheet. Arrange payroll deduction and provide Chapter 13 plan information. We recommend that all plan payments to the trustee be made through payroll deduction. We have found that cases have a better chance of success when on payroll, and you don't have to purchase a cashier's check or money order. Do you want payroll deductions? If debtor agrees to payroll deduction, print order. Explain order. Have debtor sign order. If debtor refuses payroll deduction, you should understand that if you miss a payment, the judge can order payroll deduction or dismiss your case without your permission. Explain how to make payments to our office. If the debtor agreed to payroll, explain that they should make a payment every time they are paid until they see the deductions coming out of their check. Explain information on it. Give the debtor payment envelopes. Meeting conclusion. Mr. Ms. Debtor's last name. Do you have any questions at this time? No further action required by debtor attorney. The confirmation hearing will be on date. Address debtor attorney. Our office requires no additional information or documents at this time. You may contact the trustee's attorney staff attorney name if you have any questions regarding the confirmation hearing. Good luck to you. This meeting is adjourned. If debtor attorney must do something, the confirmation hearing will be on date. Address debtor attorney. Our office requires the following things from you. State documents that must be provided or amended. State any other requirements. This must be done at least 1 week prior to the confirmation hearing. You may contact the trustee's attorney staff attorney name if you have any questions regarding the confirmation hearing. Good luck to you. This meeting is adjourned. Turn off the recorder. Excuse everyone from the room. Meeting follow-up. Enter the meeting result and any necessary notes. Print a copy of the worksheet. Make copies of the confirmation order, payroll order and any other necessary documents. File documents and return the case file to the front desk.
Debtor, case 1101111. Are there any creditors here in this case today? There are none. Is there a creditor here? Maybe stepped out. Okay. I've identified the debtor by an Oregon driver's license. The information matches that contained on the schedules. Do you have Social Security ID with you today, sir?
I forgot that.
You did, okay. Do you have a W-2 on you by chance?
No, I have a copy of my tax return, but no W-2.
Okay, well, a copy of the tax return won't do because that's a document you prepare or your tax preparer prepares and is not issued by the government. Do you have a Social Security card at home you could bring in?
Yes, I could.
Okay. What I'm going to do is I'm going to go ahead and do your hearing today, but on the record I'm going to continue it till my next hearing date, which is March 30th at 1:15 p.m. Sometime before that time you need to come to the office of the U.S. trustee, which is on the same floor, all the way around the other side of the building, and you need to go there during normal business hours and show them your photo ID and your Social Security card. Then you don't have to come back on the 30th of March.
Okay.
If you don't do that, you'd have to come back on the 30th of March at 1:15. If you don't do either of those, then I'd file a motion to dismiss your case. Okay?
Yes.
Okay. Can you state your full name and address for the record, please?
Kelvin Dana Adkins Helderson. Oh, sorry. Average debtor. 10,015 Southwest Terwilliger Boulevard, Portland, Oregon, 97219.
Okay. I hear it's kind of hard to hear in the back, so I'm going to face this way a little bit as I ask the questions. Did you have a chance to read the information sheet prepared by the Office of the U.S. Trustee, front and back?
Yes.
Okay. Did you have an opportunity to read your bankruptcy schedules, meaning your petition schedules, statement of financial affairs, and related documents carefully before you signed them?
Yes.
Did you have help in preparing your bankruptcy documents?
Yes.
Who helped you?
Professor Richard Slotty at the Lewis and Clark Legal Clinic.
Okay. And did you review those documents carefully after he prepared them?
Yes.
And did you pay him any money to assist you in that preparation?
No.
And have you listed all of your assets and did you list all of your creditors?
Yes.
Okay. And is the information in those documents true and accurate as the date you filed this case, which was January the 27th, 2011?
Yes.
Have you filed all your tax returns that are due up through 2010?
I filed the 2010 return, but I have not filed my 2009 return.
Okay. And when do you anticipate you're going to be able to file that?
I just haven't filed it because all of the money would go to my domestic support child payments, child support payments that are delinquent.
Okay.
So I just haven't filed.
I don't remember seeing an exception in the tax code for not filing just because you may have the money go to your domestic support obligations. When do you think you'd be able to get those filed?
Probably next week.
Okay. You need to be aware that there's a provision in the Bankruptcy Code that allows the court to dismiss a case if all tax returns are not filed within a certain period of time after this meeting of creditors. So it's important to do that or you may face a motion to dismiss your case.
Okay.
Do you own any real estate?
I had a house, but I sold it in 2007. And after the cost of paying the mortgage and everything, I only got about $3,000 from it.
Okay. And is that the only real estate you've owned in the last 5 years?
Yes.
Okay. And Do you own any vehicles?
Yeah, I have a 2008 Ford van.
Okay, and that's financed, correct?
Yes, it's worth about $11,000, and I owe approximately $9,567.
Okay, and are you current on those payments?
Yes,
And do you plan to keep the vehicle?
I do. I'm going to enter a reaffirmation agreement with the creditor.
Okay. And is the car fully insured?
Yes.
Do you own or have an interest in any other vehicles other than your van?
No.
Do you owe any domestic support obligations such as child support or spousal support?
Yes.
Okay, and to whom do you owe that support?
To Susie Detter, my ex-wife. I owe her $14,000 in delinquent child support that I'm paying through the state of Oregon Child Support Division.
Okay. I'm going to hand you a sheet that we call our domestic support obligation sheet. And have you filled that out completely?
Yes.
Okay. So I'll be sending a letter to the recipient of the support and the state agency that monitors support within 3 business days of today, advising them of your bankruptcy. Then I will send a second letter when you receive your discharge, advising them that your discharge has been received and whether there are any debts that are non-dischargeable or that you've reaffirmed. Okay, do you own any boats, motors, or camp trailers?
No.
Do you own any collections, antiques, or valuable jewelry?
No.
Do you own any stocks or bonds or investment accounts?
I have an IRA.
Okay, and when was that funded?
Years ago, 2004.
Okay. And does anyone owe you any money?
My employer owes me wages from the last pay period,
Okay.
$217.
Okay. And do you have any claims or lawsuits you can file against anyone, such as personal injury claims or employment claims?
No.
And was anyone garnishing your bank account or your wages within 90 days of your bankruptcy?
No.
And have you paid any money to friends or family members other than for nominal holiday gifts in the last 2 years?
No.
Did you pay any one creditor more than $600 within 90 days of your bankruptcy?
No.
And have you been a party to a divorce or separation proceeding within the last 4 years?
Yes.
And does your ex-spouse owe you any money or property?
No.
Was there a property settlement as part of your divorce, or did you each just take your own stuff and go your separate ways?
We each took our own stuff and went our separate ways.
Have you owned or operated your own business in the last 6 years?
Yes. I operated a craft supply business. From 2006 to 2008, I was a sole proprietor, and I have no remaining accounts receivable or inventory from that.
And no other assets
No.
from that business?
No.
And have you given away, sold, or transferred any assets in the last 4 years other than for normal holiday gifts?
No.
Other than the house that we've already talked about?
Yeah,
correct?
just the house.
Okay.
Just that.
And have you ever filed for bankruptcy before?
Yes. I filed Chapter 7 bankruptcy in 1999.
And did you receive your discharge?
Yes, in the beginning of 2000.
Okay. Any other filings?
No.
Okay, then other than your personal items such as clothing and furnishings, have we discussed all of your assets today?
Yeah.
Okay. All right, I see you brought with you here a bank account statement. You have the one bank account, is that right?
Yeah, for the U.S. Bank checking account.
Okay. And what about a pay stub? Did you bring the pay stub with you today?
I don't think I did.
Okay. So what I would need is your pay stub covering the date of filing, meaning that the pay period for the time period in which you filed your bankruptcy. So if you or your counsel could get that to me by email or fax, and if not, then that'll be part of the hearing on the March 30th. But otherwise, I'd like you to get that to me within a week. Can you do that?
Yes.
Okay.
Yes.
Okay, are there any creditors in attendance today? Nope.
If there were, what would happen?
If there were, I'd have them come up. There's a microphone right here. They're welcome to ask any questions that relate to the assets and the liabilities of the debtor. If there's ongoing litigation, for instance, a domestic dispute or some type of potential non-dischargeability claim, this is not the forum to come and conduct a deposition of the debtor. So if you have if the creditor has basic questions, I'm happy to entertain those. Because we handle anywhere from 5 to 8 of these every hour, we don't have a lot of time to turn it into a deposition, so I'll politely ask if the questions go too far in terms of a deposition that they schedule their own 2004 exam at a time convenient to the debtor. And because oftentimes the debtor may even be represented by counsel in that proceeding that's not even here. So it would be unfair to the debtor to have this be used as a deposition in a related but different case. Okay, so I'm going to conclude the hearing for today. I'm going to continue it on the record until March 30th at 1:15 for Social Security ID purposes, and assuming you do that and you send me your pay stub, I'm going to declare this to be a no asset case once you've done that. Okay, thank you very much.